Hello again, hope you're all doing well. It's been a minute since we've done something special. As longtime viewers know, this channel is a hobby, but I like to have some fun with it because it's something that I can't do when I'm on the appellate clock. Now, today is all about contempt, and today I'm going to cover, well, what I think are the three most interesting cases, regardless if they're published or Rule 23s. And if you didn't like the ones I picked for this year, well, there's 30 you can skim over in the monster cheat sheet. Link is in the description. Subscribers, you should have gotten a notification when the guy dropped early, and just let me know in the comments if you didn't get that notification. Now, this latest edition has clickable Pilcrows. Even Gitlin doesn't even do that, and well, you know, even if he did, you know that DLC is going to cost you like 10 gajillion bucks. So just click on the Pilcrow in the featured case. It'll take you to the exact page where I get that factor holding. I want you to trust what I do, but because we're all professionals, we always verify. And before I forget, on October 16th, I will be presenting a 90-minute CLE for the Cook County Domestic Relations Division covering, well, every case law update that I can think of under the sun. And attendees, you're going to get the mother of all cheat sheets. We're talking hundreds of cases. All right, now with the advertisement over, let's get on with the show. The first case up is this beauty. Historically, indigency has been an accepted defense for people who are ordered to pay a financial obligation like child support. But we have a long line of cases that say if you're going to raise that, you got to bring in documentation or other evidence to show that after you paid for everything you need to not die, you have nothing left. General testimony by itself is insufficient. And here, Dad brings in documentation to show he's too broke to pay court-ordered fees, but, well, the judge holds him in contempt anyways.
No way!
Yes way, but there's a method to the judge's madness. According to the opinion, Dad's made this same argument a lot of times in the past, and every time when the cuffs were getting slapped on him, the money just sort of magically appeared.
Magic!
And on top of that, the court found Dad's testimony about as credible as a politician's. And on appeal, the court says, Judge, if he's pretended in the past to be broke and you don't buy his current excuse, it's good enough for us. And they affirmed the decision. So colleagues, keep this case in your back pocket if you have an opposing party who loves to cry wolf.
Well.
Now moving on, this next case involves an attorney battling some mental health demons. It was a murder trial that was at the post-conviction stage. The attorney was defending his brother, which, probably not a good idea. The attorney gets held in contempt 4 different times by 4 different judges. His license is eventually suspended for 3 years. The defendant's post-conviction motion is denied. On appeal, he's arguing that his brother, the attorney, was ineffective at representing him. The issue on appeal is whether the contumacious conduct, that's a mouthful, can be a basis for ineffective assistance of counsel. And the appellate court says yes, as a contributing factor, because the conduct, well, it was just so over the top that it was a distraction.
Context. A billion years ago, 1982 to be exact, the appellate courts issued an analogous decision in People v. Williams. In Williams, a capital murder conviction was reversed because the lawyer was in trouble with the ARDC. Unsurprisingly, every ineffective assistance claim thereafter argued Williams. But perhaps realizing that Pandora's box was opened, the courts all said, no way bro, Williams only applies to Williams. So it's unclear whether Jackson will get the same treatment, or whether defendants can argue ineffective assistance claims when their attorneys engage in outrageous conduct.
And moving on to our final case, it involves a, well, white elephant defense, waiver. Now here the parties came to a deal on arrears. Dad's supposed to make like this lump sum partial payment, then some tiny monthly payments. But COVID happens. Dad loses his job, but Mom's lawyer says, you know what, under the circumstances, we're gonna be patient. Dad pays some of the money, but less than the agreed order required. Nobody raises a stink until a year later when Mom files for contempt and the judge is like, you kind of lured this guy into thinking you'd be cool with this. You can't come in here and sandbag him like that. The judge denies the contempt. She appeals. The appellate court's like, yeah, it's pretty clear that you waived the specific compliance by your conduct. So, colleagues, never hurts to ask the client if there's been some sort of communication about money troubles because you might have a waiver defense. And before I go, I'm just going to show one more time about that cheap is free guide. The link is in the description. It has every kind of contempt imaginable, so please check it out. Okay, next month we're going to have a short roundup on the poor man's appeal, aka the motion to reconsider. It's one of the most commonly bungled motions you'll see out there. So if you want a heads up when it all goes down, well, you know what to do. Anyway, that wraps up this month's roundup. I hope you found it helpful, and as always, thanks for watching.
Yourself all up, you tell you love yourself all up, you
yourself, I'll love you till you love yourself, and I'll sink until I love myself.